UDeCOTT and potentially in relation to other government agencies as well, a problem of securing adequate transparency in terms of the applicable procurement rules, particularly dealing with topics already mentioned. The adoption of a general and universal procedure would be greatly aid this transparency. Well, thank God for the people. Thank God for Professor.
Absolutely.
We would not know that.
Yep.
You don't learn that in UE.
No, no.
You don't learn that. Oh, well, thank God for Professor.
Oh, gosh.
Right? Another aspect of transparency is the extent to which government agencies are subject to the control and direction of government or individual ministers.
Right.
This topic has been examined specifically in relation to UDeCOTT, but it applies universally. In regard to statutory corporation, such as HDC, the statute itself empowers the minister to give instructions. It is in the interest of good management as well as transparency, this relationship needs to be clarified and ministers given express power to give instructions. One last thing I will read. Other issues which concern procurement practices and performance within the public construction sector generally include broader transparency issues, legal issues of contracts and dispute resolution, management issues, particularly problems of poor performance and planning, and other regulatory issues. These are dealt with later in this summary. So that was a little background into the commission and what they were doing and what they were doing. Let's fast forward. Today, Calder Hart, former chairman of the Urban Development Corporation of Trinidad and Tobago, has secured a legal victory at the Privy Council, as the court yesterday dismissed an appeal seeking to restore the adverse findings made against him in the Commission of Inquiry into the failed Las Alturas Towers housing project. Well, poor me thought Mr. Hart gone somewhere in the Bahamas. I didn't know he's still fighting the battles. I really was unaware. Forgive my ignorance. Good, so those of you who like to run to court, you realize how what's going on.
That's right.
He's still fighting the fight, and that not free. But remember, he was chairman. So maybe he could do it. I don't know, but it's not a nice place. So
that's right.
It's not Sunday school, right? 5 judges at the Apex Court found that the Commissioner of Inquiry, the COE, the Commission of Inquiry, had breached, and this is the important part, the fundamental principles of natural justice by failing to give Hart advance notice and an opportunity to respond to serious criticisms made against him before its 2016 report was published. The board decision upholds the findings of the local court of appeal, meaning the adverse comments and recommendations against Hart in the Commission of Inquiry report have been squashed and are of no legal effect. Yesterday we were talking about this, about the right to be heard.
Yes, that's right.
Okay?
That's right.
The appeal was brought by Dr. Myron Wing Sang Chin, one of the commissioners. The other 2 are deceased. I did not know that as well either. Who challenged the Court of Appeal's ruling in favor of Hart. The commission had investigated the construction of the multi-million Las Alturas towers in Mova, which were eventually rendered uninhabitable and demolished due to site instability. The Commission of Inquiry report had concluded that Hart, as a former chairman, was clearly the mind and the management of UDeCOTT and should be held accountable and liable for the losses sustained. Delivering the judgment, Lord Clark stressed that the Commission of Inquiry made very serious and conclusive findings of wrongdoing against Hart without allowing him to answer the criticisms beforehand.
My God.
Also, on the panel of judges were Lord Sales, Lord Leggett, Lady Rose, Lady Simler. The board rejected arguments that Hart had forfeited his right to respond because he had previously declined to give evidence to the inquiry. Lord Clark clarified that the right to notice and the opportunity to respond was independent of a person's participation as a witness.
That's right. That's right.
The court reiterated that a long-standing legal principle stated that the failure to give notice may be unfair, even if devoid of practical consequences, emphasizing that it was inappropriate to speculate that anything Hart could have said would have made no difference. The court affirmed that the commission did not comply with the law on natural justice and fairness, now embodied in Section 20 of the Judicial Review Act 2000. While the legal battle involved arguments over specific procedures, the court concluded that the central issue was the general requirement of procedural fairness. Natural justice and fairness required that Hart should have been given notice and allowed the opportunity to respond, and this outweighed any concerns about an extension of time. We talked about that yesterday as well. The judgment said. Hart was represented by Lord Barnett, Anthony Bullock, and we have all those who were on his team.
Right.
Ladies and gentlemen of the jury, Madam HR Specialist, giving someone, a worker, an employee, the right to be heard.
Yeah. I think, you know what struck me with that article? The part where they were speaking about the fact that, or they're saying that giving him a notice would not have changed the decision or changed any factor. That's interesting, because you see, what we look at in HR, the person, you have to give them that opportunity to explain themselves. Perhaps they may bring some form of evidence, some kind of information that can make them trying to, you know, the term play and mitigation, that kind of thing. It could give the panel an opportunity to see a different perspective as to why this particular situation happened. But of course, you wouldn't get another perspective if you don't give them the opportunity. There are a lot of things that you only find out when you ask the person. For example, when we have fights, and it's not supposed to have fights, but if you don't question both parties and you just judge based on the books, an innocent person who's defending themselves can get in innocent trouble.
Talked about that yesterday as well.
So you really need to hear all the facts, regardless of whether you think this situation would have turned out or happened in a particular way. It's called natural justice. Now, I cannot really look at the situation and say, well, you know, he must have had some kind of cause. I can't say that, but regardless, this is what the process entails. And that's why they suffer like this today.
Caller, good evening.
Yeah, good evening. Sorry to badger you again. I agree with Ms. Sermoya. That principle of natural justice is fundamental to decision-making of public authority and public functionary, and even the conduct of a commission of inquiry. And it's basic in the sense that you have to hear the other side. And the principle, I think in Latin they say, audi alterum partem, and the rule against bias and all these different things. But the fact remains is that it's basic. You have to hear the other side. You cannot condemn a man without giving him the opportunity to say his side. It's basic. And I don't know, I can't understand how this matter reached as far as the Privy Council. I can't understand that. And you had a case sometime in the early 80s with respect to that business, that matter in Tobago with the former Prime Minister, where again I think Justice Seeley was the person, and one of the concern was that same breach of natural justice, the person not being given the opportunity to be heard. It's basic. So I can't understand any public functionary not adhering to that basic principle. I can't understand that. And that is just one of the grounds for, again, bringing an action for judicial review. The question that probably they would have acted irrationally, they would have acted on, the question of unfairly, as you rightly pointed out there, and or unreasonable, or unlawfully. So the fact remains is that I can't understand how this matter reached the Privy Council and why the first instance court, which is the High Court, did not address that matter, and the matter went before the Court of Appeal, and they failed to address it appropriately. So I'm saying that I just want, as an aside, I am saying that we're not yet ready. I don't want to juxtapose that with the CCJ, but I'm saying that somewhere along the line, I suspect that the way we do business in Trinidad with respect to our judicial process and all that, I think that we still need to hold on to the Privy Council for some time. Thank you.
Thank you, caller. Caller, good evening.
Good evening again. As only on this judicial topic and thing, it just brought something to my mind. Donald Trump was convicted in the United States, right? Convicted of criminal activity or a felony or what have you, right? And some of us here throwing all that support behind him because you're supporting Kamala and you're doing that regardless of whatever, not standing on principle. But Maduro convicted of anything? Anybody could tell me? Or we just running on the allegations of whoever, and that is what does make you guilty now. You don't have to go through a process. The President of America was convicted and still ended up being the president. We need to check ourselves in this place seriously, Most of us from our neck up, I love that.
Principles of natural justice, which is what we're talking about. I didn't want to I ain't going to Venezuela today. No boy. Oi, no boy. No boy.
Now, they were saying that he refused to participate to some measure in the investigation. But the fact is that even though someone is refusing to participate, it doesn't take away that right for them to receive their notice. They have to be aware of the things that they are being accused of, and they still need the opportunity to defend themselves. If, once again, they refuse to participate, the documentation needs to be there, but it cannot or should not be said that they did not get that opportunity.
Because the court says that his refusal to be a witness is separate and apart from his right to answer concerning the negative things coming out of the inquiry. Caller, good evening. Caller, good evening.
Good afternoon, Shania.
Good afternoon.
And Marcus Finlay. We're talking about something else. You come here talking about Maduro and Donald Trump. Is there something wrong with them fellas and them? You come to defend Maduro. Like you have something I you take like a container. I look to listen to the program.
Callers, don't distract me today.
We're talking about
no boy a Venezuela oil. Okay? No boy a Venezuela oil. Good, we're not going Venezuela today. Good. We're talking about principles of natural justice as applied to our judicial system, our legal system, and this, as Mr. West pointed out, how is this or why was this an oversight? This is a basic principle. And Sermoya, you are HR practitioner, you do know, and I sure you would advise your colleagues that employees, and imagine that,
That's right.
So here's what we see. We see employers, in terms of discipline, in terms of industrial relations, with very good cases. Very good case. Sometimes you even know that the employee may be guilty. I have a sense that the employee may be guilty. But the employer has circumvented the process.
That's right.
Good. And tampered on the process, such as to limit or stymie the worker's right of being heard and lose the case. So an innocent, sorry, a guilty worker might walk free.
That's correct.
Because you fumble the whole ball. Before the goal, you kick wide.
Yeah,
you understand?
You anticipate so quickly. And, you know, I do believe sometimes it's a level of emotion. There's some kind of emotional investment into this matter that you feel like you have to be the one to deliver justice, but it has to take its course.
Correct. Because this, in my view, I agree with the caller. How could this be an oversight? I mean, these people know more than me, you know. These people have years of legal expertise.
But that's why they placed on the inquiry. Because you have, we recognize you have this level of expertise.
These people produce a document, you know.
Wow. And there was no attorney present on that committee. Nobody to look at that document.
This document is 512 pages, eh?
Nah. Now, you see, Calder Hart, as you kind of alluded to, he has the finances to go the distance. There are many people who wouldn't go the distance because our local industrial courts, they don't have the money to go through union and all of these kinds of things. But there are people who will go the distance with you. That is the point of this today. Some people will walk away and say, okay, I'll leave the work, I'll leave all that, that's it. There are some people who are willing to go the distance and they will embarrass your company in court.
Yeah.
And that's the reputation of HR practitioners as well.
Yes.
This cannot be an oversight.
Yeah, it can't be an oversight.
He who alleges must prove.
Okay.
The persons have to have an opportunity to face their accuser and ask the relative questions. If you look at it from your personal perspective, if someone is bringing an allegation against you, you want the opportunity to say, is that where did you get this information from? You want to ask your own questions. You want to defend yourself. So don't you think the employee or in this case, this gentleman involved, he would have that same right? Because this is his reputation, his career for all over these years. Whether he did it or not, we are not disputing that. We are talking about his process, defending his lifelong career. People's jobs are their livelihoods, and that is why industrial relations is so critical.
Or the alteram partem, here the other side, it is critical. It is crucial. You know, sometimes without hearing the other side, we misjudge and prejudge people. Eh?
That's right.
Some of us has run with talk. Eh?
Yes.
And it looks so, and it looks so, and it looks so, and everybody says so, and everybody in the office says so, and that one, the girl down by the cooler, the one who does mop the floor, says so, and all this kind of anecdotal stuff.
Information before you. No questions asked, nothing.
And the guilty party is unaware, or even if they're aware, they're not given the opportunity to be heard.
Yep.
You're putting a time frame on it and telling them, respond in 48 hours. Otherwise. Otherwise what?
Time
48 hours for me to consult? For me to say a little prayer, to check the pastor. I don't know what my sources of inspiration or counsel are. 48 hours. No, we want it now. HR will say you have to report in 48 hours. Otherwise you're fired. Well, go ahead. You create work for me. Go ahead. You create employment for me, thank you.
Yeah.
We sully the process.
Of course.
We sully the HR and the industrial relations process by denying the worker. Mr. Matheson, I am so upset he's not here because we did speak about this yesterday in our ending of our scenario with people who, how could they not understand this? That even a worker, not a worker, sorry, even an individual on a murder charge, capital punishment, has the right of appeal. Somebody who kills somebody,
they have the right.
Has to be heard. You see it on the TV all the time. The judges ask them, they'll be part of it. They're not somewhere else and you talking about them in their absence.
No, the process has to be followed. And I realize how critical that is. You know, this the Miranda rights thing, you have the right to remain silent. I've seen situations where people get off because they were not read their rights. So we have to ensure that these processes are tightly done to avoid the loopholes. Even if the party is guilty, you failing to do your part of the process could allow them to get away scot-free.
And that is deemed guilty because the process is not complete. You know, but is this an oversight? Call me. 342-0081-4665-391.
Somehow,
The off
Ronaldo,
commission.
I don't believe this is really an oversight more than an emotional response of some sort, because this has a measure of
Ego.
politics in it. So ego is probably what I want to say. There's some politics in it. At the point in time, you know, who Calder Hart was associated with. And people were emotional about this entire situation. And, okay, justice, you're guilty, corruption, you know, that was the term. Corruption flinging all over the place. So somebody had to go to jail for this.
Well, and that's the problem here. Because the people involved in this are very learned and well-respected people. This ball too big to be an oversight. It looked for me like somebody leave the door open.
Absolutely.
Somebody leave the door open, understanding that this will collapse. Given its natural course, it will abort. Call me on 342-0081-4665-391. So Mr. Hart has won his appeal at the Privy Council based on him not being afforded his basic rights. How many people in Trinidad are denied their basic rights?
Absolutely.
And that has nothing to do with guilt. You see, we associate rights with guilt.
Yes.
We associate the two. Good afternoon, caller.
Yes, good afternoon again. I just want to ask, how much of the members of parliament there's been lawyers? How much of them are lawyers?
Plenty.
They get away with what appears to be willful action.
Correct.
Willful action because they ought to know. They ought to know. I wonder if they have to be judged by their peers. If their peers who will also know, believe that they have ought to know and can conclude that the actions were malicious. And right through, we have been going through this in this country, right through. Millions and billions in litigation. In matters as Mr. West said, don't even need to reach all by the Privy Council, but what? People just feeding at the trough, and talking down to people on all different kind of platforms. It's only, I don't know when we will wake up and start to address these people because of the responsibility that we gave to them. And we gave them a good life with it too. A good life, so much that somebody could be charged. We're trying to defraud the state with this tax exemption that we give all you. It really unbearable.
Caller, stay on the line. I'm giving you some information, but don't crash your car if you're driving. Park up. You hear me? If you're driving, park up. Let me give you the information. The off commission costs approximately $46 million. Legal fees were $33.8 million. You go ahead.
And this continues to be what we go through in this country, what we endure regardless of who is in power. But they continue to get away with this type of action, right? When a whole battery of them are lawyers, it's not people who bending on the street, ending up in politics so much more than lawyers, who supposed to be well learned in the field of law to understand how to proceed with certain matters. Yet still, it's all kind of blunders that even Ray Charles could see through with the darkest shades on. But we caught up with loving political party, while they destroy this nation. Look at where we are economically. If it wasn't for Patrick Manning, I don't know how this place would have been looking, This man, he really leave a mark. When you look at Port of Spain and you see the little development, all these big buildings, the waterfront, Sapa, Napa, you name it, is a good thing for Patrick Manning. When you see the people in this country, I don't know what it will take for the eyes to open up. I'll turn Sermoya and Mr. Rollocks.
So if you feel we're playing politics, you could understand that we're not playing politics on this program.
No.
Good afternoon, caller.
Hello, good afternoon.
Yes, good afternoon, sir.
Yeah, man, the president Trinidad and Tobago village right here.
I ain't see you have a name that does show up here, but go ahead.
Yeah, I know. I just carry the phone now and then.
Yeah, switch it up on me. Go ahead, Prezi. Tell us.
I can switch right now. My internet on the next one right now. I had to put in a plan. Okay, so I come in a little late, but that is a topic since all you're talking about the office and so forth and the law. I want to ask one simple question, nothing much, because it leads into what my mind's saying. That eventually after the Privy Council, in accordance to what the Privy Council saw, and according to what are you saying, that due process wasn't held, this Mr. Hart could end up with a big piece of money eventually. I ask you a question, you know?
Yeah, we listening to you, Prezi. You go ahead. You're right.
Yeah, well, that is my question because I need an answer to that. If according to the Privy Council eventually, if the Privy Council say, well, look, this case could squash, Mr. Hart could end up with a nice piece of money. I like that. I clearly asked the question that I need an answer for.
Thank you.
Yeah, thanks.
Thank you, Prezi.
All right.
Thank you, Prezi.
That's some figures you call them, man. That's some serious figures.
Yeah, I joke money.
And you pay that kind of money, but yet we still have this blunder. This is a major blunder. This man win this case.
But they could have asked you somewhere. You could have do that matter.
That is what I'm saying.
You would not make that error. A women boy matters when you need them, right?
That is some serious money, and on top of paying that, you now have to pay for this matter here because you lost. The state had to pay. This is crazy.
3420081466539 taxpayers' money.
That's what I was just about to say. I wonder how you're feeling as these citizens to hear that this kind of these figures that's spent already, and now that he has won this matter, the state will have to pay.
Caller, good evening.
Hey, good night. The point that the caller made earlier, the last caller that made, just to reference what happened with Petrochin and the A.B. Trillion matter. Simple case. Senior counsel went and argued in the court. He just argued principles of natural justice, and they won a couple $100 million. So that could give you a perspective on what the possible potential outcome is going to be as it relates to cost. But I want to just make a comment on something else in line with that. Earlier in the program, you're making a point about why is it that people continue to violate the principles of natural justice, even though, so you talk about employers, you talk about different institutions, not just companies, but institutions that is. And I have an opinion that the state the government as an entity, not as a political party, but as an entity, has deliberately allowed that to exist as a problem for the purposes of people benefiting, not just money, but people also benefiting from the opportunity to get away from having to answer for things that they did. And I will proffer an argument as to evidence of this fact, of my point, evidence of my point. the government, the state has never put forward a national policy on natural justice or attempted any legislation for establishing natural justice as a point of law for people to follow. What you have is legal precedent, the argument of common law for establishing principles of natural justice. In simple language, it's an understanding. And that is, in my view, the reason why we continue to have it as a violation. You see, everybody they have an interpretation and an opinion of how the principles of natural justice is to be applied. However, there's enough legal precedent set in both locally and internationally for clarifying how it is. However, those legal precedents is available for practitioners, not necessarily available for the average person, the average business person, the average corporate person, etc., etc. I have an opinion that is deliberate, and that will continue to be like that because it is an opportunity not just to earn money, but for people to get away with the things that they do from time to time. Thank you.
All right. I do not totally share that view. I think I understand what the caller is trying to hint, but my bias is my extensive knowledge and experience in terms of the judgments coming out of the industrial court and the principles of natural justice, not just as established by precedent, but as written in the literature.
Yes.
I mean, our own jurisprudence has established these things as serious principles, and they are recorded, they're written on their books on it, their HR people know about it. I mean, I think I understand. Well, the caller, the work did say that it is now part of the Judicial Review Act 2000, right? So maybe there's a law on it in that respect. But in terms of industrial relations, the industrial court has a plethora of judgments citing this. Actually, this is one of the key ways in which to fumble the ball.
That's right.
And
That's
as a consultant, and even Sermoya as a consultant yourself, I am sure that you would have advised employers about this.
That's right. That's right. This is a critical mistake to make. You see, what we have to remember is that employees can say anything. If I'm taking it just from the workplace perspective, employees can say anything. You know, so I've seen, and I was working with Matteson at one point in the security industry, and there would be officers who would refuse to receive their notice of investigation. I've seen where managers drop it at their feet, because it would not say that you did not receive this letter. Even if we have to email a soft copy to you, we will do what we have to do to show you receive the information, because we understand that blunder could put our case in jeopardy.
Yeah, and for the people who think that it's an IR or HR matter, it's a fundamental principle of all law. Criminal law has the same principle.
People must have the right to know.
Somebody accused on murder, on state capital offense, has the right, not only the right to be heard, he has the right of appeal.
That's right.
It could go further. We're not even dealing with appeal. As you see exercised by Mr. Hart, you do have a right of appeal. No, that's not an existential right. You know, it doesn't just exist without end. But you do have a right of appeal.
That's right.
And if you have a right of appeal, the corollary is you do have a right to be heard. And that right to be heard has other things in it. So for instance, if I do have the right to be heard, then obviously I have a right to know the information.
That's right.
To which I have to respond.
Information relative to this allegation.
So you can't deny me the information and then ask me to say what?
Yep. Because you don't know what you're being accused.
But I should still come and say, well, I can't answer because you have not given me disclosure.
Yep.
Well, that's the legal term for it.
That's
you know,
correct.
you have not given me disclosure. You have not told me, you know, but you have all the papers in front of you. So what we say in the tribunals is that my client has had no sight of that document.
Yeah. Yeah.
My client has never seen that document. For those of you, and I'm speaking into the mic now, for the HR people who like to hide people file.
That is madness. If
And
some
don't
employee
show
want to
workers
see
their
their file,
file.
they have a right to see the contents of their file.
Don't take it out of
That's
the
their
office.
information.
We have to watch it when I hear. And you're slipping things on people's files and bringing it to the
That
court.
is bare madness. Whatever you give them, a copy would be on the file. It shouldn't be news.
We like surprise. We like we catch it. We like the boss mark. That's not how IR
It's
and
not
HR
the
works.
employment relationship at all.
No, you don't boss no mark. The employee must be aware
That's
of the
right.
information you've been
That's right.
collating on their file.
Even in instances where another employee comes to complain, because that happens to me a lot. People will come in, HR, I just want to discuss something with you. I start by saying, first of all, if this is a complaint, does this person know that you're complaining? I think we need to have a meeting. And when we start going down that road, you'll say, no, I just come to, you can't come to
You
just
come to
tell
snitch.
me. You come to put me in place. Because the first thing you will do is say, HR is aware.
Yeah.
This is not a
HR is
counseling
getting real
session.
back on the line.
Watch
I don't
now.
really like HR sometimes, though.
Yeah, but there's
Well, the
probably
accusation, yes, the
there is
accusation
probably
level against HR.
And I mean, we just switching a little bit. The HR career is so difficult that they want you to be the counselor and then they want you to be defender at the same time. Which one do you want?
Then they say HR is mind people business.
So I just get right
But
to
then
the
we
business.
ask you who you tell, and you say you tell HR. But you
And
have
then
to
when you
tell
sit down
HR.
with HR, you say, well, I just come to talk about it.
Yeah.
Do you want me to do something about it?
No,
Can
don't
we
call
have a
my name.
meeting? No, I don't want to
call
have
my
a meeting
name,
with
Mr.
nobody.
Moya.
So
I
then,
just telling you what I see, but don't call my name.
but when things start to blow up now, but HR was informed. That is the confusion. So now you meet a different beast. Everything I want in writing now.
But the worker has a right to know.
Simple as that.
The
You can't
worker
come and
has a right
accuse
to-
somebody.
You can't accuse somebody in secret.
What am I writing about? We need to come together and say, this person has accused you of this. What do you have to say about it? Give the person the opportunity to explain themselves.
And if the person doesn't have the opportunity to face their accuser,
Then it's bacchanal. Then it's bacchanal.
so apparently Mr. Hart was denied notice or the opportunity to respond to the negative
He have to be able to
adverse findings
respond.
or conclusions before it was published. So you can imagine reading this in the news.
My God.
Lord Jesus. I have money to pay that chairman.
Yeah.
Because if I was that chairman, we will call him Chairman 7. C7.
C7 boy.
Calling him C7 because it's about 7 company. Right?
Wow.
If y'all don't have money to pay that C7, good?
Man, reputation and damage.
So I read in the
if he
papers
not
that
guilty.
Miss Sermoya was down the road, spotted so and so, and she jumped the fence. And Miss Sermoya reading that in the papers. Big investigation. But the way Miss Sermoya learned about the outcome of the investigation
It's in the public
is in
just
the
like
papers.
everybody else.
Nobody write Miss Sermoya and say, well, Miss Sermoya, we unearthed these things. What do you say? Do you deny it? It's untrue. Look a copy. Look it over. How could this be an oversight?
We tend to treat fairness as though it's a favor. Eh?
And we treat, yes, correct. You're very correct.
This
Say that again.
this is not a favor. Fairness is not a favor. It is a right.
Correct.
It's a right.
Correct.
We tend to forget how we would feel if we are placed in that situation. I tend to
Correct.
go right back to that. We only understand when we are in the situation. I realize we do the same thing even when there's a big something happened, some type of murder or whatever. Jail them. But the person has a right to be represented by an attorney
I
and
just be
face
the one
court.
saying jail them too, to be honest. Let me
No,
confess.
but so that is so ingrained in our culture.
Yeah. Lock
when
him
we
up.
get into the workplace, especially if it's the
Shoot him.
employee that we cannot stand, I am telling you,
Fire
you
him.
do it. You do it.
Because he did it last time.
Because you do it the last time.
He like to
but
touch.
still, the justice has to prevail. It has to go through the process.
Yeah.
If we keep that in our minds and think about the kind of money it will cost the company, you will just hold back your emotions and say, okay, let's get through this process.
And it's the same thing we keep, but how could this be an error?
I am surprised with the levels, the persons on that tribunal. I am really surprised. But Just because somebody has a career and they have letters behind their name, it doesn't mean that they are not susceptible to mistakes.
Wow.
I think we tend to forget that people like the big name, Dr. So-and-so, Professor so-and-so, but these people are human beings, and they would have gone through trial and error in their careers and in their lives just like everyone else.
Call us on 3420081 466-5391. Natural justice.
Natural justice.
The denial of natural justice to anyone. It really circumvents the entire process.
This is serious.
It sullies the process. You might have been going good
yes.
in your little HR process,
yes.
but you see that? Somebody say, don't tell him. Don't show him that letter. Don't let him know we had a letter on file. Eh? You are doing yourself no good.
That's right.
That is stupidity.
That's right.
That is how the worker will win.
Of course.
I will win that matter.
You can't deny them their rights. You can't deny them an opportunity to have representation. It has to be fair. And companies do that as well. They come in meeting with a big lawyer, but the person cannot come with a representative. Why?
Yeah.
These things aren't fair.
Yeah, it's crazy. It's crazy. And sometimes we see the system collapsing, and we want to know how and why. And it's these simple things. But ego, you know, you said that. Ego causes us to turn a blind eye to some basic things.
Yeah.
Because we believe that the other person is not worthy
That's right.
of it. I don't want to hear nothing he has to say. Send him home. All right.
We get that right through.
Send him home. Send him home and let him come to me. Right? You'll pay him for that.
Wow.
You'll have to pay him for that.
Yeah,
They'll have to pay him for that.
Right. They have their rights, and you know, in life, that's how we treat situations. From the time we come to a conclusion, we jump in, nosedive into the conclusion, and refuse to give people opportunities. And you know, to me, this situation should be an example for life. We really need to avoid being hasty.
Correct.
And seeing it on social media all over. Somebody will come up with a story and people just run with it. And then you have this back and forth banter. We had a similar situation over social media this week self.
Yeah.
People need to have the opportunity to say yay or nay. You can't just run out and start doing what you want.
Yeah,
it damages people's reputation.
I hear he do it already. People say the same. That kind of thing we want. We want to bring
it happens. That's our culture too.
Yeah.
So
and we convict people based on these things.
Yes, it's unfortunate.
You know? And it's unfortunate, and these people end up, the state pays, you pay, your taxpayers pay.
And then your reputation, because you know what, people just say, hey, he's a big old thief.
Yeah.
Those things hurt.
Yeah. So we do have to be careful, and now $44 million later. 44.
Counting what the government going to pay now, eh?
For those of you who wanted to go Venezuela with us, that's 44. Yes, 44 million dollars later. We have discovered that Chairman C7 was denied his natural rights. No big. We ain't getting into no criminal thing yet. You know. Imagine that. We're not even getting into the sophisticated thing and embezzlement. And it's like, you just denied this gentleman
his rights.
His rights.
All that money went down the drain. And I would like to, I hope that should we have other commissions of inquiry, that we use this example and build out some type of standards of operating procedures. This is what is supposed to happen. Ensure that these activities happen before you produce a report. It's not too basic because you're so high and you have all of this career, because these are educated people that made this blunder. I think you need to have standards. I would like to believe that's already there, but have a training session, have it reinforced before the investigation takes place. They have some remedial work to do. We have to go to the back of the class, man.
The right to be heard. The right of disclosure.
Absolutely.
To tell somebody what they're being accused of.
That's right.
And to give them the evidence or the basis upon which you have arrived at that conclusion.
That's right.
Don't say because you know and we say so, and this one did see, and the person who see do have a name.
Exactly.
So I can't really question
can't
nor
question.
cross-examine the person. So them just see, or you convict people based on hearsay.
Yep.
And that can't be how we approaching
That's
discipline in the workplace.
That's right.
Worse yet, commissions of inquiry. We deal with workplace. We ain't high up like commission
Yeah.
of inquiry. But this was a $44 million, 33 in legal fees. Good?
Wow. So that means this had to go through attorneys.
Yeah. So the attorneys
again,
make more than the commissioners, basically. You know? And this can't be right. It can't be right. We can't keep this as commonplace in Trinidad and
course
Tobago.
not.
2025,
Of
it's
course
too costly.
Yep.
And I hope this bat inside does not do the same
Again,
thing.
That's correct.
Because it will be costly, especially if there's a change at the next time we vote. We're going right back into uncovering some of these unfair decisions. You've been a good pavilion today, and thank you for giving us that time.